In this lecture, we want to talk about governance and race relations in the New South. Remember that the New South began properly after 1877, which is the beginning of our concern with the history of the U.S. in this course. But we have to reach back a little bit into the earlier 1870s to understand the governance structure and the race relation structure that pertained throughout the South into the 20th century. In the immediate aftermath of the Civil War, the South went through a governmental change known as Reconstruction. At first, under presidential Reconstruction, so-called, states could be readmitted to the Union upon some reasonably light qualifications, but with the politics of the era, eventually Congress overthrew presidential Reconstruction and imposed what many in the South called radical Reconstruction, what historians tend to refer to as congressional Reconstruction, and then in some areas, or actually throughout the South, but in some areas more stridently than others, part of congressional Reconstruction was military Reconstruction. During that period, from approximately 1867 to 1877, we also see at the state level a destruction of the old Reconstruction governments that the so-called Reconstruction governments that historians of the South used to talk about as being dominated by Republicans and dominated by African American former slaves, or even a few cases freemen, then really only lasted a couple of years, maybe 4 years at the most, except in South Carolina and in Louisiana, where they lasted just slightly longer. But throughout the rest of the South, beginning in about 1870, even in the middle of congressional Reconstruction, we see state legislatures and constitutional officers coming from the old agrarian elite that had predominated during and after the during and before the Civil War. This was the reemergence of what they called conservative rule, this reestablishment of so-called conservative rule, a reestablishment of Democrats, many unreconstructed. Many who had served in legislatures during and before the Civil War, and those who had not, often sided with those who had served in the legislatures during and before the Civil War. If they liked themselves, if they liked their, anybody who talked about this, if they liked what was going on, this conservative reestablishment, they called it the Redeemers. If they didn't like what was going on, they called these people Bourbons, not because of the drink that they may have favored. We don't know what they did or did not favor, but because that's what French historians had called the reestablished French court of Louis XVIII and Charles X. In which particularly Talleyrand had said that these reestablished conservative monarchs who had come back in after the French Revolution and after Napoleon had learned nothing but forgotten nothing of the previous era. That means they did not learn the lessons of the revolution, and so were likely to just attempt to reestablish pre-revolutionary times, and that they had forgotten nothing, which meant that they were very resentful of those people that they remembered had humiliated their families or humiliated them. So those who disliked the new conservative governments that emerged between 1870 and 1874 is when they began coming back, and they dominated state legislatures into the 1900s, then called these guys Bourbons. And it was a mocking name. They called themselves conservatives. And without exception, they were Democrats. They tended to ally with Northern capitalists. And here is where we see redemption policies at their greatest flow, you might say. What did these redeemers want? Well, mostly they wanted to reverse the trend of the previous legislatures, that is, of these Republican legislatures, and reduce public expenditures on public goods. That is, they reduced spending on education throughout the 20 or 30 years that they ruled the roost. They reduced expenditures on penitentiaries, which led directly to the convict leasing system that was so prevalent, particularly after 1900, when states simply could not fund their own prisons, and so they let convicts out as chattel property. They rented them to miners and farmers and other people who could pay for their use. This was a pretty heinous system from any point of view. It generated a fair amount of money for the states, but it really was it was terrible for the prisoners, and eventually it took a while, but eventually it was discarded. And there was almost no expenditure on public infrastructure. Roads were still taken care of at the county level, where taxes were kept low by local people who didn't want to pay for roads that went places they didn't want to go, and bridges that they didn't feel like they needed, even if later they ended up needing them. They still didn't want to pay for them. So the state expended almost no money on infrastructure. Because these redeemers tended to be allied with Northern capitalists, or at least they wanted to attract Northern capital, then they established tax policies that were favorable to manufacturing. They instigated laws that were very much anti-labor, anti-union. They did not favor things like mechanics liens. For example, if a company went bankrupt, who got all of the money? Well, the first person up to the bar was not the worker who had not yet been paid wages. In fact, they were last. It was the creditors who received the assets of the corporation under law. And many times, the workers who had been living literally from paycheck to paycheck simply were not paid if the company went under. Later, there were some railroad regulations. Alabama in 1907 saw some railroad regulations, for example, but this benefited a segment of the manufacturing area, the manufacturing sector of the economy against the railroads, which was transportation sector. Iron makers and textile manufacturers received the benefit of railroad regulation, in addition to some larger farmers. Politically, also, then these Bourbon governments were white supremacist. That is, they wrote into state law and allowed counties and municipalities to write into local law white supremacist and pro-segregationist laws. This was an era in which we see a change from de jure separation of the races, de facto separation of the races, that is, an agreed upon set of social mores that defined place in a system in which the races of Caucasians and African Americans were in close physical proximity to each other, but in definite social distance from one another, being replaced by laws that mandated physical separation of the races. Now, there's a fair amount of scholarship on why this occurred, and to me, the most convincing is the argument that said that in antebellum South, that because there were such strict laws that defined the social and even personal place of whites and blacks, of free and slave, even of white free and black free peoples, that and because whites were so obviously dominant and blacks so obviously subservient, that everybody could relax, and except for times when there was fear among the white population of black rebellion, that there was no real reason to despise for the political system dominated by whites to create laws based on the despising of the presence of black people and the fear of the presence of black people. This argument goes on to say that after emancipation, then black people lived in their own areas and white people lived in their own physical areas, and there was less and less and less contact between the races in an informal manner, and that as black emancipation allowed for greater rights, whites frequently felt that it made them less secure. And so the political system responded by creating laws that mandated physical separation, and many people, mostly the theories are aimed at whites, but I assume this occurred in the black community as well, then began fearing one another. And this fear led to even more physical separation and even more legal separation of the races. This is when white supremacy became hardened, and became written into law rather than just assumed as a social mores. There's also another idea at play here, that there were paternalist obligations on the part of slave owners towards slaves, that in many cases pro-slavery people in antebellum America argued that made slave owners the best friend of slaves. That's a tough argument to make, but go with it. Whereas wage laborers then were just another commodity. And I think this argument pertains as well. Why were white folks' attitudes toward blacks and the legal system attitude toward African Americans so hard after the 1870s? And I think a lot of it has to do with physical separation, cultural separation, fear, and the commodification of black labor. This happened with poor whites too, where their labor was commodified. There was a greater disdain in the social system built into it. Well, nevertheless, this is what white supremacy came to be in the South in those 30, 40, 50, 60 years after the Civil War. The Bourbons, however, were personally and early on paternalistic. They had been the old plantation owners. They had always been secure in their place in the system. But a generation later, 2 generations later, then we see that that paternalism in which they the Bourbons, particularly the plantation owners, would offer protection and patronage in exchange for votes. Then we saw the development, like I was just talking about, of de jure as well as de facto segregation, and ultimately the enshrinement of physical segregation into the law in an era called Jim Crow. The quote-unquote Jim Crow laws are those laws that specified physical separation of the races as well as social segregation of African Americans from whites. White supremacy in a couple of generations after the Civil War trumped the paternalistic connection between the white elites and blacks. White elites abandoned blacks to the fury of poor whites who were in direct competition with blacks for jobs, and then that idea was used to keep labor organizing at bay. All of this led to political disfranchisement of African Americans and even poor whites in new constitutions written in every state of the South, or in significant amendments to constitutions written across the South between 1897 and 1909. Now, one of the most important, let me get to the constitutions in just a second. In the early 1890s, there was late 1880s, early 1890s, there was a spate of laws that in just about every state of the South that began the physical separation of the races, or rather mandated the physical separation of the races. These were Jim Crow laws. Some of these laws had to do with accommodations on common carriers, such as trains. And in 1891, I believe, Louisiana passed such a law, and it was challenged by a man you see pictured here named Homer Plessy. The way he challenged it was to let it be known when he was riding in a first-class white-only car that he was indeed a black man. And you can see from this picture, I mean, it's hard to judge race from a photograph, but this image of Homer Plessy makes him look not African American in that stereotypic fashion. But Louisiana was the only state that did not conform to the so-called one drop rule, that if you possessed one drop, if you were a white person possessing one drop of African American or Native American blood, then you would be classified as African American or Native American and non-white. Homer Plessy, without the characteristic physical features and dark skin of African Americans, was indeed what in the parlance of the legal system of Louisiana, a mulatto. I believe he was what they called an octoroon. That means that one of his grandparents was black. Yes, one of his grandparents was black. And he was physically could pass for a white man, but he let it be known that he was black. He refused to move to the black coach because he wanted to test this law. He was arrested. Subsequently, his trial resulted in his conviction for violating the segregation law, and he took it all the way to the Supreme Court, Plessy versus Ferguson, which was decided in 1896 in favor of segregation. This kicked open the doors, you might say, to a spate of Jim Crow laws, And then it also kicked open the doors to the disfranchisement of black and poor white voters in those constitutions that were written between 1897 and 1909. The way to keep white voters who were quote unquote trustworthy in the system was to put in grandfather clauses, and that's where we get this term grandfather clause from. If your grandfather fought for the Confederacy, then you could retain your right to vote without having to jump through any of the other hoops, like pass a literacy test or pay a poll tax. Eventually, all voters were subject to poll taxes, that is, payment for the right to vote. They were all subject to literacy tests and later subject to understanding clauses. That is, the local registrar could demand that they answer questions mostly about understanding parts of the Constitution or parts of the state constitution or parts of state law. But by the 1950s and 60s, it had degenerated into a lot of silly questions that were blatantly illegal and foolish. As far as poll taxes go, they lasted into the into the 1960s. I distinctly remember my mother in Huntsville, Alabama, talking about having to go pay her poll tax. And poll taxes were cumulative. If you did not pay them one year, you owed them the next year. The upside was that these poll taxes were frequently not indexed to inflation. And so what a poll tax of $1.50 in 1890 in a cash flow economy was a substantial amount of money. But a poll tax in 1960 of that same $1.50 was merely an annoyance. Nevertheless, these were mechanisms by which race relations were hardened and became creatures of law rather than creatures of social mores. And you be the judge of which one of those was more strident and more difficult to eradicate later on. One way to enforce particularly extra legal discipline, in the sense that Michel Foucault talks about it in his book Discipline and Punish, the way to enforce Jim Crow was through lynching. And we see a spate of lynchings between 1890 and 1910. Now, this map shows 1882 to 1927, and that really is pretty inclusive. The big public festival lynchings really began in the early 1890s, and they faded out about the time of the First World War. But for 20 years, which is a pretty long time, there were significant numbers of lynchings, as you can see here. Not just in the South. You see a large number of lynchings in the West as well. But the racial lynchings, those that were predominantly of African Americans for crimes such as robbery, murder, rape, things like that, really took place in the old Confederacy and states associated with the old Confederacy, particularly in the Deep South. And in fact, it was a mechanism by which the white community could discipline and punish individual members or indeed the entire black community. These big spectacle lynchings in particular, in which entire communities turned out and made a festival out of murdering someone, was really a community mechanism by which to keep African Americans in their place. And with that sad note, this concludes our discussion of governance and race relations in the so-called New South. Thank you.